the first lecture or the first presentation that we have. And we'll have applying of theoretical and practical considerations regarding the Council decision. And we have Jūlija Muraru Kļučica from the Ministry of Justice. So the floor is yours. Dear colleagues, experts, also experts from our partner countries, practitioners from the EU member states, I have the honor today to share our experience of how we implemented this framework decision, not only in Latvia, but also in general in the EU. So this framework decision 909, I would like to draw attention to very important aspects that our experts face and our practitioners face on a daily basis when recognizing and enforcing custodial judgments in the EU. So the following issues you see also on the slide: the subjects who have the right to initiate the procedure, also assessment of social reintegration. And I would say that this is one of the central questions in the whole procedure, then respecting human rights of the sentenced person and the recognition procedure and pre-trial or temporary detention. I will start with the subjects that have the right to initiate the proceedings in Latvia. So, of course, this is the sentencing country. And if the person issuing state, and if the person wants to serve the sentence here, or if a citizen of Latvia is in another member state and wants to serve the sentence in that country where he or she resides and then Latvia has the right to initiate the proceedings and send the judgment, forward the judgment for assessment to the respective member state. Not quite rarely, and yet we have such cases when the prison administration or the prison initiate the proceedings and inform the Ministry of Justice, which is the central institution, and ask the ministry to verify these proceedings and then transfer for enforcement to the respective member state. The next subject which can initiate proceedings is the competent authority of the executing state, which, for example, receives an application by a sentenced person. And so this competent authority then sends the request to the Ministry of Justice to start this verification proceedings. And the next subject is the sentenced person or the representative of a sentenced person. Most frequently, well, this is the most frequent type. We have all kinds of cases. We even have phone calls coming from prisons in other countries. They phone the ministry. A person phones the ministry and asks, what should I do? I would like to serve my sentence in the country of my citizenship. Or the representative of a sentenced person submits this application to the Ministry of Justice requesting initiation of these proceedings. Well, the next aspect is, again, the role of the court, those who pass the judgment, who control enforcement of the judgment. The court, when it delivers the judgment and when the judgment has entered into force, then the court receives information from the sentenced person or sees that the sentenced person is in a member state. The court should approach the Ministry of Justice with this application. And it's very important in this document to describe the details. For example, the substance of this request, why this case should be forwarded to the competent authority to another state. And here I start already speaking about the possibilities of social reintegration. Then, of course, also the legal qualification of the committed offense should be provided, and of the facts of the case, and also information should be provided about the person and the link that the person has with the country where he or she wants to serve the sentence. Of course, you you should annex also the judgment, order on enforcement of the judgment, then articles from the penal code, from the criminal code, because the Ministry of Justice is the central institution, and in Latvia it is responsible for filling out those certificates. And that's why we request the courts to forward to us as detailed information as possible that would allow us to understand whether we can start consultations. And the next question is about the members, the sovereign competence of the issuing state regarding enforcement of the sentence. It's not always when we receive an application from a sentenced person. Well, the issuing state should respond and send a request to the competent authority of the country which is going to assess this request and possibility to serve the sentence. Why so? Because there are several aspects that should be taken into account. The issuing state assesses where the term would be shorter. We are also taking into account pre-term release conditions. In Latvia, these terms are more favorable, and that would be better for this person to serve the sentence in Latvia. Then another another point, sometimes interests of social reintegration are not taken into consideration. Latvia might have some concerns that the person, upon being forwarded to another country, the person might return to the criminal environment. And this aspect is very important, and judges should take this into consideration. This should be taken into account, and we should understand how this can be assessed. The next issue, which I already mentioned at the beginning of my presentation, is that assessment of social reintegration. Social reintegration is the social link with a member state where the person will continue serving the sentence. So social reintegration is a very important aspect of the framework decision. And I hope that all practitioners and experts and judges of member states really pay attention to this aspect. So the competent authority of the issuing state should feel convinced that the serving of the sentence in the executing state will really facilitate reintegration of the sentenced person in society. So in this stage, we have to be very careful, and each issue, each case, each application should be assessed on case-by-case basis. Because there's no ready-made scheme that could be applied, and that would tell me that this standard exists and the standard criteria should be examined, because each case is unique. So social reintegration, those elements in social reintegration, and even the definition is not clearly provided in the framework decision, but in practice we see a number of elements that reveal this connection and link of the person to the executing state. First of all, a place where the person is linked to the family. Of course, we have to understand whether in the country where he or she wants to serve the sentence, the family resides, for example, spouse or children, also language. Language is a very important aspect. That's communication. And we have to understand why this person wants to be transferred to that particular country. We have to understand whether, if he wants to be transferred to Germany, whether the person is proficient in German.
Culture is also an important criteria, the ability to adjust to local circumstances as well as social and economic and other ties like employment are also factors to be considered. As regards to the human rights of the sentenced persons, this is a very, very important question. Throughout the project, we had a lot of discussions and a lot of debate on whether the sentenced person should be given an opportunity to serve their sentence in their country of origin, the country of which they are a citizen, and this is very closely linked to the Human Rights Convention, Article 5, the right to freedom. And why am I mentioning this article in particular? Well, we have to basically evaluate whether the sentenced person will be able to serve faster, and where those preferred conditions will lead to early release. So in our experience, when we see that conditions are better in other member states, we do apply that, but we also noticed a problem that might be relevant to other member states as well. And I'm talking about the consent of another member state to transfer a Latvian national to Latvia, where the judge of a competent court in Latvia finds out that the conditions for the early release are much more favorable in other member states. And the question is how to act in such a case. Well, usually the way we go about it is that the Ministry of Justice notifies the member state that they have better release conditions in their state, and quite often, despite favorable release conditions and requirements, nevertheless, those member states decide to transfer the person to Latvia, and then the sentenced person starts complaining and appealing, and they are appealing to their human rights and right to freedom, and so on and so forth. So I would like to urge everyone to think about this side of the topic or the issue that we are dealing with, because most probably you might face such appeals and such questions. And we are also required to provide the information upon the request of the executing or executing country. Not always do we get notified about early release, which is significant in how we respond to these requests. And that is why when you send the certification, when you send the documents, there's a table where you have to basically check or include the articles or references to the criminal law as regards to early release of a convict or sentenced person. So when should we provide this information? Option 1, before recognizing the sentence and enforcing it. So basically before Latvian judge decides to recognize the court decision of another member state, we have an opportunity to request additional information before the enforcement. So if additional information, additional details are necessary from another member state, I as an expert always say that you need to consult, you need to get in touch and request additional information. Another option as regards to the notification on early release conditions, it should be provided along with the rejection to recognize and enforce the judgment. So in Latvia, we have quite efficient practices for rejecting such requests in cases when it is justified, and it is justified when, for example, their conditions, sentencing conditions as well as serving conditions are more favorable in another member state. As far as recognition is concerned, when a person is in the executing country, you need to request the executing country to apply an arrest or detention to the sentenced person, which means that the member state needs to notify Latvia, for example, about temporary detention of a sentenced person when this person is residing in Latvia. So you can do it before the actual sending or before receiving the judgment and other documentation. So you can request this before you are requested to enforce and recognize. So That means that you have received the form, recognition certificate, and are yet to decide the case as a judge, and then you can ask for temporary detention. What you need to know is that you cannot extend the sentencing by the period of the temporary detention for the recognition. And then there's also another aspect that I would like to draw your attention to. This is a big problem that for the European Union, and I'm talking about the deadlines that are set in the framework decision, set out in the framework decision. According to the framework decision, we have to comply with specific deadlines, one of which is 30 days. So you need to decide on recognition or non-recognition of a request from another competent member state court in 30 days, whereas the decision needs to be taken 90 days or 3 months after receiving an official formal notification of recognition. So basically you have to decide on the sentencing according to Latvian legislation 90 days. So as far as our practices are concerned, after the initial decision on the recognition, the court then requests the state police to organize the actual transfer of the person from one member state to another member state. It is important to understand that police must also comply with 30 deadline for the transfer of a sentenced person, which is quite, short, in fact. But if we all comply with these deadlines, then everything will work efficiently, I suppose. Another important problem which impedes the efficient procedures, and these are problems or barriers that stem from EU bureaucracy, not always forms or templates are precisely filled out or correctly filled out, which means that, for example, Latvia receives a special form or notification or a request, or certificate rather, and sees that there's some information missing. We have to return it and ask for additional information, which is a waste of time. So be very careful about these forms, about these certificates. Another problem is the quality of translation of these documents. Sometimes we do get complaints from practitioners on the ground who are working with sentencing documents. We have complaints about the quality of translation. Sometimes the quality of translation is poor and you need to request additional translation. There are also communication problems or barriers when consulting with colleagues in other member states. I would like to urge, all the experts and practitioners who are responsible for these matters to communicate and provide information as much as possible, because quite often you send a notification or request additional information from your colleague in another country, and then, the silence for a while. Then you have to send a reminder, please let us know, because that will determine our follow-up actions or further actions, because a person is waiting in jail, waiting for the transfer, but there's no information and lack of communication to facilitate such transfer. So do not neglect the communication, please. As regards to the deadlines, I already mentioned those deadlines. We need to stick very carefully to those deadlines. As regards to information, the quality or the integrity of the information, it is very important to provide the information about the stages of the proceedings, about the sentencing, and about the enforcement. We don't always get full information about sentencing or the conviction of this person. So we have to ask, what is happening with this person? Are they still jailed? How's sentencing being enforced? So that's another problem of the EU level. As regards to future problems with regard to transfer of persons, there's an interesting notion, the right to be notified about the transfer to another country for serving your conviction. There's a directive 2012-2019 which determines the legal victims' legal rights during the transfer. We must also take into account the rights of victims in the process of the enforcement and transfer of persons. This is something from the future, but this definitely will come up at various EU working groups. It's just a matter of time. And then we should also evaluate the imprisonment conditions. Is it being done? Is the imprisonment conditions being assessed by practitioners, and whether they are assessing these imprisonment conditions, but because that has a direct link with human rights of sentenced persons. So this is something that we should all also think about in future. So thank you for your attention. That's all from me.